झारखंड के मुख्यमंत्री हेमंत सोरेन ने कैबिनेट बैठक में दो बड़े फैसले लिए। पहला, झारखंड में 1932 के खतियान आधारित स्थानीय नीति को मंजूरी मिली है, तो दूसरा, ओबीसी, एसटी और एससी के आरक्षण में बढ़ोतरी का फैसला किया गया है। अब इन विधेयकों को विधानसभा से पास करवाने के बाद केंद्र सरकार को भेजा जाएगा। दोनों ही विधेयकों को 9वीं अनुसूची में शामिल करने के लिए केंद्र से अनुरोध किया जाएगा और 9वीं अनुसूची में शामिल होने के बाद ही ये झारखंड में लागू होगा।
Hello everyone, welcome to Topic of the Day. In today's video, we shall be discussing about the 9th schedule of Constitution and Judicial Scrutiny. Now recently, this topic came up in news as the Jharkhand Assembly cleared two bills, one for increasing reservation and another for determining domicile status. Now the first bill, Jharkhand Reservation of Vacancies in Posts and Services Bill 2022, raises reservation to 77% in vacant government posts and services in the state. The second bill, Jharkhand Definition of Local Persons for extending the consequential, social, cultural and other benefits to such local persons Bill 2022, uses land records with 1932 as the cutoff year to determine domicile status and define local residents. Now, why was there the need to include it in the 9th schedule? Chief Minister Hemant Soren said that the bills would come into force only after the centre carries out amendments to include these in the 9th schedule of the Constitution. The 77% reservation breaches the 50% ceiling set by the Supreme Court in the landmark 1992 Indra Sawhney versus Union of India verdict. However, placing a legislation in the 9th schedule shields it from judicial scrutiny. Now, talking about the previous instances in the TamilNadu case, the TamilNadu backward classes, scheduled castes and scheduled tribes, reservation of seats in educational institutions and of appointments or posts in the services under the State Act 1993 reserves 69% of seats in colleges and jobs in the state government. Now, when it ran out legal obstacles in 1990s after the Supreme Court verdict, the then Chief Minister Jayalalitha led a delegation to New Delhi to meet the then Prime Minister P.V. Narasimha Rao. The reservation provision was then included in the 9th schedule. So now let us discuss about the 9th schedule of the Constitution. The 9th schedule contains a list of central and state laws which cannot be challenged in courts. It became a part of the Constitution in 1951 when the document was amended for the very first time. It was created by the new Article 31B, which, along with Article 31A, was brought in by the government to protect laws related to the agrarian reform and for abolishing the zamindari system. When Article 31A extended protection to classes of laws, Article 31B shields specific laws or enactments. Now, talking about the laws under 9th schedule, the first amendment added 13 laws to the schedule. Subsequent amendments in 1955, 1964, 71, 74, 75, 76, 1984, 1990, 1994 and 1999 have taken number of laws protected from judicial review to 284. Now, most of the laws protected under the schedule concern agriculture or land issues. Now, are the laws in the 9th schedule completely exempt from the judicial scrutiny? While the 9th schedule provides the law with a safe harbor from judicial review, the protection is not blanket. Now let us also discuss the verdict in IR Coelho versus State of Tamil Nadu, case 2007. When the Tamil Nadu law was challenged in 2007, the Supreme Court ruled that while laws placed under the 9th schedule cannot be challenged on the grounds of violation of fundamental rights, they can be challenged on the ground of violating the basic structure of the Constitution. The laws cannot escape the basic structure test if inserted into the 9th schedule after 1973, as it was in 1973 that the basic structure test was evolved in the Keshwanand Bharti case as the ultimate test to examine the constitutional validity of laws. Further on, if a law violates the basic structure doctrine, such law will have to be invalidated in exercise of judicial review power of the court. So this was a little bit about the topic, that is the 9th schedule of the Constitution. Now let us take up one practice question on the same. Consider the following statements relating to the 9th schedule. First, it contains a list of central and state laws which cannot be challenged in the courts. Second, It became a part of the Constitution in the year 1955 when the document was amended for the first time. Now, which of the statements given above is correct? You can take a moment and write your answers in the comment section below. Now here only the first statement is correct. The second statement is wrong as the ninth schedule became a part of the Constitution in the year 1951 when the document was amended for the first time, and it is not 1955. Therefore the correct answer is 1 only, that is option A. Well, with this we call it a wrap of today's edition of Topic of the Day. I hope you liked the video. You can also check out the daily current affairs section on our website for further details, and for more such videos, do stay tuned to the next IAS YouTube channel.